What you are about to hear is a story about 97. 97 separate claims, 11 weeks of trial, 45 actual court days of testimony and cross-examination and legal argument, and a judge who dismissed every single one of them. Not most, not the majority, every single one, without exception. Hello, friends. My name is James, and you are watching Royal Daily Report, your #1 source for the most exclusive and most shocking royal stories on the internet. If you are new here, hit that subscribe button right now, because tonight we are giving you the full story of Harry's catastrophic court defeat. Not the headline version, the complete version, every detail, every contradiction, every consequence. And if you have been with us from the beginning, you already know, we never hold back. We never pull back. Let us get into it. And before we go one single word further, if you are not subscribed to Royal Daily Report, you are missing the most important royal legal coverage anywhere on the internet right now. Hit that subscribe button, turn on those notifications, because this story is still developing, and the cost hearing at the end of July could be even more significant than the verdict itself. Subscribe now. Let us get into it. 97. That number needs to sit with you before anything else in this story, because it tells you something that a simple headline never quite manages to convey. This was not a narrow loss. This was not a case where a handful of allegations held up while others quietly fell apart. Harry brought 97 separate claims against the publishers of the Daily Mail and the Mail on Sunday, and the judge dismissed every single one of them, all of them, without exception. And the way it happened, where Harry was when the verdict came through, what he had prepared in advance, and what the judge specifically said about his evidence, is the story we are telling tonight in full. Subscribe to Royal Daily Report right now, because the specific detail that actually decided this case in practice, the detail that most outlets buried underneath the headline number, is coming right now. Hit that button, turn on those notifications, subscribe now. Let us start with what actually decided this case, because the number 97 and the word 0 tell you the outcome, but they do not tell you why. And the why is the most important part. Under oath, in front of the full court, Harry testified that his inner circle was tightly guarded. No close friendships with journalists whatsoever. No one positioned in a way that would allow them to leak private information about him. His exact words to the court: "My social circles were not leaky." I want to make that absolutely clear. That specific claim was the foundation the entire 97 claim case rested on. Because if his circle genuinely was as leak-proof as he described under oath, the only remaining explanation for how private stories consistently reached newspapers was unlawful information gathering, phone hacking, private investigators operating outside the law, exactly the conduct he was accusing the Mail of throughout the trial. Then the Mail's legal team produced a set of years-old Facebook messages between Harry and Charlotte Griffiths, the Mail on Sunday's royal writer, and the tone of those messages did significant damage to the picture Harry had just painted under oath. The messages were casual, familiar, unmistakably friendly. "Hi, it's H," one message read, followed by, in case she was confused by the photo. Griffiths replied, "Hello, Mr. Mischief." The exchange continued back and forth on a first-name basis, across multiple messages, and at one point specifically referenced missing their movie snuggles together, a phrase that instantly became one of the most quoted lines to come out of the entire 11-week trial, repeated across nearly every outlet covering the case. According to arguments presented in court, Griffiths had kept these messages private for more than a decade before they surfaced during the proceedings, introduced specifically after her credibility had been challenged. A witness who states under oath that no relationships of this kind existed, and is then confronted with direct documentary evidence proving that at least one clearly did, invites much closer scrutiny of everything else in their testimony. Not because the messages themselves were scandalous, but because the contradiction itself becomes the story. The High Court judgment found that Harry gave limited evidence on the issues at the heart of the case and strayed beyond factual evidence while in the witness box. Reports from inside the courtroom described the presiding judge intervening more than once during the testimony, specifically to redirect Harry back toward answering the actual questions being asked of him. And exchanges between Harry and the male's legal team grew noticeably more adversarial and more tense as the testimony continued across multiple days. Subscribe to Royal Daily Report right now, because where Harry actually was when the verdict came through, and what he had prepared in advance, is the kind of detail that tells you everything about how confident his team actually was going into that final judgment. Subscribe now. Hit that button. Turn on those notifications. Subscribe now. Harry reportedly arrived in Britain for this particular week with 2 entirely separate speeches already prepared in advance. One written specifically for a win, one written specifically for a loss. He was at a public Invictus event at Chatham House at the exact moment the verdict came through, surrounded by veterans, with cameras actively rolling throughout, when someone quietly stepped over to him and delivered the news of the verdict in person. He never once got to use the version of the speech he had genuinely hoped and prepared to use. His voice was shaking when he subsequently spoke. He was visibly alone. Meghan was not by his side. She and the children had remained in the United States throughout the entire duration of the visit. Now, there is a genuine and important side of this case that actually worked in Harry's favor, and basic fairness requires naming it properly. The court heard allegations that a private investigator working on behalf of the male obtained the specific airline seat number of Chelsea Davy, Harry's former girlfriend, and discussed the possibility of placing someone in the seat directly beside her during an international flight. If that account is accurate, that represents genuinely disturbing conduct by any reasonable standard. The court also heard direct testimony from Elton John and his husband David Furnish, who said under oath that they genuinely believed their newborn son's private birth certificate and confidential medical records had been improperly accessed. These are serious allegations, and they deserve to be taken seriously on their own terms, regardless of where the broader case landed. But here is the legal distinction that actually decided the entire outcome. Alleging a privacy violation, however serious and however genuinely felt, is simply not the same thing as proving one under the specific legal standard that applies in a civil case. This was a civil case. The standard was the balance of probabilities, meaning simply what was more likely than not. Even applying that comparatively lower legal bar, the judge repeatedly and consistently looked for specific concrete evidence, demonstrating that any given particular piece of information could genuinely only have come from unlawful means, rather than from any of the numerous ordinary channels through which royal information typically circulates. Many of the individual claims dated back 20 or even 30 years, meaning they relied heavily on inference and reasonable assumption rather than on direct documentary evidence. The ruling was explicit. Inference alone, however serious, is generally not legally sufficient on its own to decide a civil case of this scale. Subscribe to Royal Daily Report right now, because the human story sitting inside this case, the journalist who defended her reporting while recovering from major cancer surgery, the judge's specific finding about her credibility, and what it means for royal journalism going forward, is all coming right now. Subscribe, hit that button, turn on those notifications. Subscribe now. Royal journalist Katie Nicholl has covered this family on Fleet Street for roughly 20 years. 17 of her own individual articles were examined in detail during these proceedings. Her sources and her specific reporting methods were challenged directly in open court in front of lawyers and a judge. At the exact same time, she was recovering from major cancer surgery. At one point, she said she could barely manage a flight of stairs and still had to dig through old notebooks to defend reporting she had completed years earlier. Recovering physically from major surgery, and simultaneously having your entire professional credibility built up over 2 decades, publicly tested and challenged in a courtroom, both happening at exactly the same time. When the ruling came down, the judge did not simply dismiss the claims connected to her reporting and move on. He went considerably further, describing her explicitly as a credible and impressive witness and formally accepting her evidence as honest and reliable. Speaking publicly afterward, visibly emotional, she reflected honestly on what 20 years in journalism had actually involved. Not the glamour that outsiders sometimes imagine, but the far less glamorous reality of knocking on doors repeatedly, building genuine trust slowly and patiently over time, earning reliable sources through years of consistent, unglamorous relationship-based work. She described one particular source in specific detail, a woman in her 70s who had been genuinely close to the late Queen during her lifetime, who eventually agreed to speak with Nicol only after years of relationship building, because Nicol had earned that trust gradually, through old-fashioned patient reporting, rather than through anything even remotely resembling unlawful methods. "I did journalism the hard way," she said. "I never witnessed anything in terms of what we were accused of doing." Tom Bauer's assessment of the verdict was measured in tone, but sharp in its substance. "The judge has been remarkably brave," he said, "because to punch Harry on the nose so violently, and although he has not called him a liar, implies that he did not believe a word of his evidence." Bauer went further when asked about the future of Harry and Meghan's marriage. His answer was considerably more pointed than most commentary on that subject tends to be. He said he believes the marriage will continue going forward, but specifically for reasons of practical necessity, rather than genuine ongoing love. In his stated assessment, the two of them now depend on each other more than at any previous point, precisely because their various business ventures have significantly underperformed, leaving them, in his view, increasingly reliant on protecting a shared public image together, rather than independently choosing each other for their own sake. Subscribe to Royal Daily Report right now, because the financial consequences of this verdict, the numbers that most outlets have not fully calculated for their audiences, are the part of this story that is still unfolding right now. Subscribe now. Hit that button. Turn on those notifications. Subscribe now. The cost involved in this litigation is enormous, on a scale that most people following the case struggled to fully grasp until the specific figures started circulating. Under the loser pays principle that applies broadly in civil litigation in the UK, the unsuccessful party can be legally required to contribute meaningfully to the winning side's own legal costs. Before the trial had even properly begun, the court was told that combined legal costs across both sides could realistically approach £40 million in total. By the time the full proceedings had concluded, after 11 weeks and 45 separate court days, some reported estimates put that combined figure considerably closer to £50 million altogether. Insurance arrangements may cover part of that figure, but depending on the final cost order issued by the court and the specific policy terms involved, there could still be a genuinely substantial financial balance left outstanding. A further formal hearing is scheduled for the end of July, specifically to determine exactly how those substantial costs get allocated between the parties, and our source says that hearing could be as significant as the verdict itself. Paul Dacre, the Mail's editor-in-chief, responded to the verdict with characteristic bluntness. He criticized Harry's memoir directly, arguing it exposed private family matters, while Harry simultaneously complained about his own privacy being violated. "There is not a laundry in the cosmos big enough to wash all the dirty linen Harry has aired about his own family," Dacre said, adding that Harry's privacy arguments take not just the biscuit but the whole tin. He went further, claiming that Diana herself had, during some of the most difficult years of her own life, personally read and genuinely trusted the Mail as a publication. There is also a detail about the run-up to this trial that matters considerably more than it might initially appear. Reports indicate that before the case even formally began, Harry's own legal team quietly explored the genuine possibility of a financial settlement around the Christmas period. Well over half a year before the eventual judgment was handed down, according to those same reports, the Mail specifically declined that settlement opportunity and chose instead to defend the case fully in open court, a decision that once the verdict came in, overwhelmingly in their favor, a great many commentators pointed to as reflecting genuine institutional confidence in their legal position, alongside a real willingness to have all of the underlying evidence tested publicly and rigorously, despite the enormous financial cost that decision ultimately carried for both sides. Harry was far from the only claimant involved in this case. Elton John, Elizabeth Hurley, Sadie Frost, the David Furnish, former MP Simon Hughes, and Baroness Doreen Lawrence were all involved. Simon Hughes publicly described the outcome as very disappointing in his statement afterward. Tom Bower, despite years of often harsh public criticism of Harry, specifically said the person he personally felt the most genuine sympathy for was Baroness Doreen Lawrence, whose son Stephen Lawrence was murdered in a racially motivated attack decades earlier in one of the most significant cases in modern British legal history. Bower specifically noted the complexity of her position. A woman suing a newspaper that had for years campaigned to help bring her son's killers to justice. Some commentators have pointed out that Harry has the financial resources and the established public profile to absorb a defeat of this particular scale in a way that not every individual claimant attached to this same case genuinely can. All of this landed cumulatively during what a great many commentators have described as one of the single most difficult stretches of Harry's entire public life since he formally stepped back from royal duties. Reports indicate that Buckingham Palace had initially offered him accommodation during this specific UK visit, an offer that was later formally withdrawn after a decision on accepting it was reportedly not made within the required time frame. Meghan and the children remained in the United States throughout the entire duration, adding yet another layer to an already difficult and heavily scrutinized week. And entirely separately, the Invictus Games Foundation, the cause most closely and personally tied to his public identity, was facing its own significant financial pressures heading into the coming games. To a great many observers watching all of this unfold in real time across multiple simultaneous news cycles, it genuinely looked like another opportunity for reconnection, with the palace had quietly slipped away yet again, while his family stayed an entire ocean apart from him. Right at the exact moment, a £50 million legal defeat became the week's single dominant headline across every major outlet. 97 claims, 0 surviving, 11 weeks, 45 court days, movie snuggles on Facebook, a judge who found his evidence wanting, a journalist who defended her reporting while barely able to climb a flight of stairs, and who was found to be credible and impressive and honest, a cost hearing still to come at the end of July that could add millions more, and a week in which Harry stood in a room full of veterans with cameras rolling and received the worst professional news of his life alone, without his wife, without his father meeting him afterward, without the win speech he had prepared, with only the loss speech he had hoped never to use. That is all for tonight, friends. I am James, and this has been Royal Daily Report. If this story hit different for you tonight, hit that like button right now, subscribe if you have not already, and turn on those notifications, because we are covering the July cost hearing the moment it happens, and every single development in this story as it unfolds. Share this tonight with someone who has been following this case and who deserves the full picture, not just the 97-0 headline. Subscribe now. Tell 5 friends. I will see you in the next one. Until then, stay informed, stay curious, and stay royal. Goodbye, friends.